A very good evening to one and all present here. On behalf of the National Law University Meghalaya, we extend a warm and heartfelt welcome to the valedictory ceremony of the second National Moot Court Competition 2025-26. It has been a remarkable journey of legal brilliance, persuasive advocacy, and courtroom intellect over the last 2 days.
Established with a vision to foster legal excellence, Nlu Meghalaya has quickly grown into a hub of rigorous academic inquiry and impactful legal education. With its commitment to nurturing future leaders in law, the university proudly hosted its second National Moot Court competition, a platform that witnessed spirited legal debates and outstanding advocacy from some of the brightest law students across the nation.
To begin the ceremony on a graceful note, we request our VC sir to usher esteemed dignitary, Honorable Madam Justice Indra Banerjee ma'am, former Judge Supreme Court of India, to kindly come on the stage.
I now request VC Sir to kindly felicitate Honorable Madam Justice Indira Banerjee for gracing this occasion with her invaluable presence. Thank you, sir. Thank you, ma'am. Now, it is my honor to introduce our Vice Chancellor, Professor Dr. Indrajit Dubey, the visionary guiding the path of National Law University Meghalaya, a leader and scholar whose dream is to shape our university into one that harmonizes knowledge creation with global standards and cultivates minds that respond to the dynamic needs of our society. Under his leadership, NLU Meghalaya stands as a fertile ground for future legal minds that will go on to define the frameworks of a just society. Ladies and gentlemen, now I invite Professor Dr. Indrajit Dubey, Vice Chancellor of NLU Meghalaya, to deliver the welcome address. Sir, the stage is yours.
Good evening, and I believe all of you have still a little bit of energy left for this session. Honorable Justice Indira Banerjee, Professor Anurag Goel, I fondly call him Goel sir, last almost 16 years. My bright boys, students, Rishabh, Abhishek, Pranay, Rohit, my dear student, my dear faculty, all looks very young. Sometimes people get confused that they are student or their faculty. and participant all across the country, uh, staffs, the university. I'm happy to report that this time, when Jogesh was spearheading this particular process of second moot court, with Jogesh, I think Uma and Ankita also joined hand, and all the faculty are supporting this process. Jogesh came to me and said, "Sir, we have to have the second round on the moot court." The first thing I asked him, "Have you raised the fund?" So, I mean, we have made a process, madam, here that whatever the outreach activity we do, we generally get the fund from other agencies, not from the university. And last year it was funded by NHRC, National Human Rights Commission. And then he, with enthusiasm, he told, "Yes, sir, we got the fund from CM. There is some fund from the CM." So I said, "Is it sufficient?" Then he called a jolt that is it a sufficient or not. But nevertheless, I believe Mutko team, in his leadership, manage the fund, and they're very innovative in that. They said, "Sir, you don't have to worry about the food and all this thing, because the excess credit which is there in the student fund, they are going to contribute it back for this moot court." So what I wanted to say that they were very, very innovative, and the urge to uh, organize the second round of the moot court, because the tradition they wanted to continue. I believe it was of its kind, because no law school in the country or university in the country has done the moot court in the first year. So we were started this university very quickly. In three and a half months we have translated this university. First year they have conducted the moot court, and they wanted to tradition to continue to have a second moot court. Then I was telling that, "Have you developed the problem?" He said, "Yes, sir, problem is ready." I said, "Who has done that?" He said, "Sir, Pranay sir has done that." Then I was telling, "Well, what is the problem?" Because I wanted that there should be some kind of a difference in the making of the problem, and we have to have a different narration. Like other day, uh, our chancellor Justice Mukherjee told that your problem is too complex, and if it has been argued in Supreme Court, they will charge 10 lakhs of rupees per appearance. So I found that there is also innovation. They have done quite a thoughtful problem in developing this thing. And then he was keep on repeatedly coming to me and telling, "Sir, can you go ahead with this?" So one day I think I have WhatsApp to him. I did not say that, "Well, go ahead." I just sent a WhatsApp and I said, "Go ahead." Now the core of this university is innovation, and that's what I was explaining in the morning also, that in the country, when we have started the law school, I mean, law school was first experimented in 1989 with National Law University. But the major experiment after that was Jodhpur, because Jodhpur has given many, benchmarking or the milestone for the law school. We have first time designed the honors program in Jodhpur with a domain. And those are not been heard of, like corporate law honors, constitutional law honors, then IP honors and all this. In the Jodhpur also, we have also developed the pedagogy quite in advance than whatever has been done in the earlier model of law school like Nalsar or NLSIU or NLIU. And there we have consciously decided that moot court should be the part of the active, I mean, daily teaching, or the part of the daily, I mean, courses, every courses. But and after that, possibly the Rajiv Gandhi School of Intellectual Property was a next generation experiment, where we thought that we're only going to teach the engineer and the scientist to make them lawyer, because we need to have those people who can really understand the legal narration in the technology environment. And I believe that particular exercise was quite successful, and you can see the success behind, I mean, in front of you. But when I got this particular opportunity here, and I remember I met with my chancellor at the time, Justice Sanjeev Banerjee. I told him, said, there is no point to repeat again or copying again another law school. We need to do something, because the format which we are until now using, it is dated now. We need a different kind of lawyer who can really operate in the technological environment. And though there is a difference of opinion, in fact, I do have always with honorable judges many of the time when I meet that some people's, I mean, most of the time the position is the judges cannot be replaced, by the technology. So last day when I was talking with my chancellor, and my chancellor is very conservative. He don't really like, technological operation many of the places. And I told him that, sir, possibly the 80% or more than that will be replaced in 10 years by the machine. I'll quote one of my student. He is a Jodhpur grad. He is running the farms now. I think you know Samir Jain. Samir was telling, sir, I have deployed AI in all my offices. I think he is running the 7 offices in different country now. So there will be change into the process, and we need to have a manpower ready for that particular environment itself. I'm not going into the argument that it will be replace the human manpower or not human manpower, but the working environment will be different, and we need a people who can really work in that particular environment itself. To say so, we are not going to change the core. We are going to have the core as it is. And when Madam today said that your problem was very good, I got reassured, because this is a problem which has been developed into the technological platform and technology related issue, and whereas it is touch upon many things. I think last 20 years I've taught competition law, I've taught the corporate law, I've taught the contracts, and it is changing very very fast. Like one of the question which Rishabh asked today, that question was mostly about the pre-compliance, and we really not taught the student that how to react in a pre-compliance environment, because until now regulatory environment which we understood, it is a post-compliance environment, not the pre-compliance environment. And the nature of the law will be changed as we are going ahead, because law has been thought as a reactive instrument and protection of the right, okay, and it is more of an anthropocentric understanding. So we do not have understanding at present that how you are going to react in a technology environment. I personally working on this AI and corporate governance for last 15 years. And when you were talking, sorry, last 10 years, and when you were talking about the designing of the liability, there is a no consensus, in international even. Though we have a some understanding about the working in an environment where human not in operations, like environment jurisprudence and all those places, but we really do not have understanding that how to work in a technological environment. So we thought that we need to design the program quite differently, and we should focus more on the domain, because now the law study should be fact based study instead of a right based study. So we have designed a program like BS Data Science, BA Policy Science and Law, and BBA FinTech and Law, because where the legal interface is very, very high. We have also redefined the pedagogy, content delivery, content curation, absorption of the information which we are delivering. And I was talking with Honorable Justice in the morning, Justice Bashar, that we are also working on the immersion, how you are going to absorb the content which has been delivered. So we have a immersion lab. In fact, Uma is championing that particular thing, and we wanted to have a virtual environment tomorrow for the purpose of the learning. And all these particular processes require, because the next generation of the lawyer will require to be different than what the generations here. I'm not going into the argument that we are going to job loss, we're going to have a different thing, but what we require a different breed of lawyer in the next generation, and that's what we focus in Nlu Meghalaya. We are also aspire to be futuristic university, and somebody was taking my interview and was telling that how we are going to define the futuristic university, and I said that we have to reorient ourselves to focus on personalized learning and research based learning, not whatever we have understood before, creating a standardized skill. We need to have a very creative mind for tomorrow, and that's the reason we are interested to develop a concept called digital twin university, which is not been done yet. And to speak it in a very simplest manner, it is basically simulation of everything before you translate into the real life scenario. So we are aspire to redefine the legal education, for that matter, higher education itself, and which is my favorite question. In fact, nowadays I keep on telling in all the platform that do you require to have a university anymore? Because you have everything now under your fingertip. If you want to go to the Gemini and if you ask that create a course for me on the concession agreement with a reference, it will give you everything that how you are going to study that particular subject in a systematic manner with the reference. So in that scenario, what is the role of university? Why the university should exist? And that particular question I think we should ask again and again, because until unless we are conscious that what we are doing, we are end up creating the manpower tomorrow who might not be relevant to the generations which are coming. So your exercise, the mooting exercise, I found the brilliance which you have tried to bring in. Many of the point which you have raised, I was sitting in the back and I was hearing. I was not expecting that to be raised by the student of your level, like fourth year or third year, or when you are not in advanced level. So overall, it is very promising, and I believe all of you have done a great job, either participating or organizing, both the way. And I have all appreciation for all of you. You have done a great job. Thank you so much to the organizing team under the leadership of Jogesh Road sir. As you call me Jogesh, it is not Yogesh. So I call him generally Jogesh, not from why Yogesh. So under the leadership of Jogesh, Uma, Ankita, all other faculty members, all other students who has tirelessly worked to put the thing very smooth. In fact, this time the moot court was compressed, uh, and to be honest, I will tell you, it is done because of the financial reason. I was telling, cut down the cost. So don't make it 3 days, because the major problem here is the accommodation. We don't have a hostel where we can accommodate our student and or the participating student. So in these 2 days, they have done a wonderful, delivery, such a well organized. And yesterday he was telling, sir, now this year really I did not put my head too much because students are now ready. They can themselves organize the thing. So if that is a opinion of him, I believe we have achieved the milestone. Because in a university, even how to be a leader or give a leadership to the issues which is your hand, or the problem which is in your hand, or action which you have to take it, that itself a great learning. Thank you so much once again, and I thank you to madam for taking pain to travel from Calcutta to here. It is really honor for us, and thank you so much, madam, once again for accepting my invitation.
Thank you so much, sir, for your insightful words. We now move to the felicitation of our esteemed judges, whose critical insights and judicial acumen made the final round a truly enriching experience. May I first invite Counsel Rishabh Sancheti Sir, Supreme Court of India, on stage to receive a token of appreciation for his valuable contribution. We request our Honorable Vice Chancellor Sir to kindly do the honors.
Thank you, sir. I'd now like to invite Advocate Rohit Jain, Managing Partner at Singhania & Co., to the stage. Sir, your observation and thoughtful engagement truly enriched the final round. I request VC Sir to kindly present the token of appreciation.
Thank you, sir. May I now invite Padma Priya Ma'am, Advocate, Supreme Court of India, whose judicial insight elevated the standards of today's round. We request Vice Chancellor Sir to kindly felicitate her. Thank you, ma'am, and thank you, sir. Moving towards Honorable Madam Justice Indira Banerjee, ma'am. She earned her LLB degree from Calcutta University. She was enrolled as an advocate in 1985 and practiced across various branches of law before being elevated as a permanent judge of the Calcutta High Court in 2002. Her illustrious journey includes serving as a judge of the Delhi High Court, Chief Justice of the Madras High Court, and finally, as a judge of the Supreme Court of India. I now respectfully invite Honorable Madam Justice Indira Banerjee to kindly address the gathering.
Professor Dr. Dubey, Vice Chancellor of the National Law University, Shillong, Mr. Goel, Mr. Rishabh Sancheti, Ms. Padma Priya, Mr. Rohit Jain, I'm getting old, the Pranay and Abhishek. Members of the faculty and my dear students. First of all, I thank Professor Dr. Dubey and his team for giving me the opportunity to be here in this lovely town, Shillong. For all Bengalis, Shillong is associated with Sheshir Kobita, written by Rabindranath Tagore. So, those who have visited Shillong in the past and those who haven't have an association with Shillong nevertheless. It's a lovely town. It was a pleasure being here. Your hospitality was absolutely impeccable. When I was invited to come here, as you can see, I'm a little incapacitated today because of a fall I had a few days back. I was also feeling a little embarrassed about attending a formal function in a dress which is not my normal dress form on such occasions. But be that as it may, I said yes because I see in the law students the future of the Indian judiciary. I assume that many of you will practice law. I hope some of you will join the judiciary. Some of you may even take up corporate jobs or jobs with law firms, as is common. But whatever you do, your knowledge of law is going to be extremely useful, not only to you, but to the society to which you belong. When we talk about the judiciary, it's not just the judges alone who make up the judiciary. It is the judges who write the judgments, who pronounce the judgments. It is the lawyers who argue before the judges. It is other stakeholders, including the litigants who come before the courts. And many of you may join such concerns as law officers. I have seen many law graduates also take up the competitive examinations and become bureaucrats. With your knowledge of law, with your legal acumen, you can always help the government administer the law better. First of all, I congratulate all the participants who participated in the Moot Court competition. Participation in the Moot Court competition must have taught you that what is important is to be able to participate and get the feel of a real court. students nowadays are lucky because of the vast improvement in the standard of law teaching in this country. When we graduated in law, and it was just mentioned that I did my law from the Calcutta University College of Law, which was at that point of time perhaps the best law institution in the city. We were taught absolutely nothing. Real learning started when I started deviling in the chambers of Mr. Shomaraditya Pal. Some of you may have read his books because of the books he's written on constitutional law, on the Contempt of Courts Act, public service, so on and so forth. He was one of the top constitutional lawyers of the Calcutta High Court who practiced in different courts all over the country. It was really after I joined his chambers that I really started learning. That's where I learned the alphabets of law. Look at the advantage which you students are getting today. It pains me to make a reference, but I can't help it. The scathing comments which was made about law education in this country by a law commission headed by none other than Justice Setalvad, which is referred to as the Setalvad Commission. The lawyers were described as parasites who knew absolutely nothing. It is not that you did not have brilliant lawyers even then. You had legal luminaries. You have had a Justice Krishna Iyer and many others. I'm just naming one. But that was probably because of their own efforts and not what was really taught to them in the law college. I still remember when I was at school at Loreto House, we used to participate in debates. But when I was first told to appear in a court, I found my throat going all dry. You know, a courtroom full of people in black robes like penguins all over the place. Crowded courtrooms in Calcutta High Court. A solemn judge sitting on the bench with a solemn face. You know, one would go there and wonder, what do you do? How do you address the court? But you are appearing before judges. Sometimes you have sitting judges coming and judging your moot courts, or else you have retired judges coming and judging your moot courts. All the legal luminaries before me, Dr. Dubey is the proud father who has produced such brilliant lawyers who have been very successful in their respective fields. All of them, it's unfortunate, many of them, given the offer, would probably refuse judgeship and say, we earn much more than what a judge earns, so we are not going to take up judgeship even when it is offered to them. But what I'm trying to impress upon you is that look at the experience which you are gathering. I was quietly listening to the questions which were being put by my brothers and sister on the bench, and how the participants were tackling those questions. Sometimes, when we judge moot courts, we probably forget that the participants before us are not experienced lawyers, but are only law students who are learning the law. I also congratulate you on the selection of the subject, whoever's idea it is, whoever has formed whoever has initially prepared the case memorial. I must say that it dealt with the Constitution of India, it dealt with the competition law, it dealt with the Consumer Protection Act, it dealt with the Digital Data Protection Act, and so on. These are useful statutes which we need all the time. You know, in India, we have a vibrant constitution, a people-centric constitution. The opening words of the constitution are, "We, the people of India, having resolved to constitute India into a socialist democratic republic," to which the words secular and socialist were added by the 42nd Amendment. What does the Constitution promise to its people? The Constitution promises to all citizens of this country justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote amongst all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Integrity, again, was added by the 42nd Amendment. We have an idealistic constitution. Look at what it promises. The object of the Constitution, it is succinctly summarized in its preamble. Then, what is there in the preamble is elaborated in the form of the fundamental rights, very valuable rights under the Constitution of India. And today, you also had a brush, at least in the last round, you had a brush with Article 19(1)(g) of the Constitution of India, which is a fundamental right. You have the directive principles of principles of state policy. There are other provisions of the Constitution. Under the scheme of our Constitution, we have separation of powers in this country. We have the legislature, which enacts the law. You have the executive, the bureaucracy, which executes the law. And then you have the judiciary, which interprets the law. And as interpreter of the law, the judiciary is often referred to as the guardian of the Constitution because it upholds constitutional rights and enforces constitutional obligations. When we talk about the rights which are available, yes, you have the state. The fundamental rights are available against the state. The state is undoubtedly under an obligation to give effect to the Constitution. But as had been said by Dr. Ambedkar, Dr. B.R. Ambedkar, who is referred to as the father of the Constitution, and also by many others in the initial speeches that were given, that how well a constitution functions depends on the people who are responsible for the functioning of the constitution. I shouldn't use the word court because I may not be using the exact words, but to summarize what Dr. Ambedkar had said, a good constitution can become a bad constitution if those who administer the constitution are incapable, incompetent. And a not so good constitution can become a good constitution if those who administer the constitution are people of competence. Words are there in the Constitution, but disputes arise, differences arise over interpretation, as has been happening at the Moot court today. Now let us say, you have the word secularism. What exactly does the word secular mean? The word secular can mean different things. Many of you are perhaps aware that the Constitution of Bangladesh is also a secular constitution. The word secular is there, but Bangladesh is an Islamic state. It applies to many other Islamic states where they use the word secular, though the state is Islamic, the state has a religion. In our country, the Supreme Court has defined what a secular state is. A secular state today, by virtue of the interpretation made by the Supreme Court, is a state which does not profess any religion and which treats all the citizens equally, irrespective of their faith, irrespective of their religious belief. Similarly, there are many other provisions of the Constitution which need to be interpreted. In the recent past, you may have been reading the newspapers. You have possibly read about the case of the Tamil Nadu governor who was found to have been not clearing bills for a considerable period of time. The matter came to the Supreme Court, and the Supreme Court said, no, you have to decide one way or the other. And within a reasonable time, you have to send it back. And if the elected government, the governor acts on the aid and advice of the Council of Ministers. Therefore, if the elected government sends it back again, then the governor has to put his signature. Now, what are the circumstances in which the governor can refuse to sign? How long can the president hold on to a statute when it is placed before him for his assent? These are issues which are invariably decided by the judiciary. You have other problems. You have the issue of defection in politics. Therefore, our Constitution has introduced the 10th schedule, under which a legislator who contests from a specific party, but after being contested, if he resigns from the party, or if he changes his party affiliation, or if he refuses to obey the instructions given by the whip of the party, then he may be disqualified. Now, when orders of disqualification are passed by the Speaker, they are often challenged in the courts. Petitions are also filed alleging that the Speaker is not acting on a complaint made by one set of legislators against another. It is the judiciary which has to decide. From the morning when we get up till the time we go to bed, we are governed by law. Now, let us say the first thing, we all belong to a family. So there is a family law, whether it is statutory, whether it is the Shariat law, whether it is the Christian law, Parsi law, there is a law which governs family relationship. There is a law which governs succession. The next thing, many of us engage help at home. So the Contract Act comes into, the Contract Act is operated, is attracted, it comes into, it governs, the Contract Act governs the relationship between the employer and the person who has been employed. Then you eat your breakfast, you buy Maggi noodles, which say it will be prepared in 2 minutes, but you find it is taking 10 minutes. You find a price, the price has been deleted, and taking advantage of the scarcity of the item, a trader is charging whatever price he likes. You have a Consumer Protection Act, and depending on the value, you go to the district forum or to the state commission or maybe the National Commission. Many of you may work with the government. Many of you may be working with non-government organizations. Here, apart from the normal Contract Act, you may have service rules. You may have the Industrial Disputes Act may be attracted. There is a differentiation between the blue-collar employees, the white-collar employees, and then the industrial employees who get the protection of the Industrial Disputes Act. And then, what are the exemptions? In contract, a contract would be meaningless if you didn't have a remedy. So, when there is breach of contract, your remedy either lies by way of specific performance or by way of damages, which you can claim against the other party for breach of contract. In what circumstances is a contract not specifically enforceable? It's important to know these things. Unfortunately, ignorance of the law is no defense. So all of you before me who are getting such good education, you can at least make others aware of the law in this country, and you can sensitize others. And I sincerely hope that you will give back a little of what you gain from this society by helping the underprivileged, by doing some legal aid work. Of course, the legal services authorities also pay nowadays, though the fees may not always match the fees which may be payable by the private litigants and by corporate litigants. Why did I refer to all these things? These are things you know. These are things which are obvious. But I want to emphasize the importance of the judiciary in this country for all the rights which I have mentioned. Now, when you talk about social rights, you have atrocities against oppressed classes. You may have discrimination against women. There may be domestic violence. There may be sexual harassment at the workplace. Domestic abuse, domestic violence at home. Then, of course, sexual assault and other things. Where do the victims go? It is to a law-knowing person. They go to a lawyer. If you are a practicing lawyer, you help them out. Even if you are not a practicing lawyer, you can advise them as to what they should do, who they should approach, who they should go to. So those of you who are going to qualify in another few years to be lawyers have a tremendously important role to play in society. Now, coming back again to the moot courts, which give you the feel of real court appearance. I can give you certain tips which are important for all lawyers. You have to remember You have joined a profession where there is no alternative to hard work. Intelligence is important, but hard work is indispensable, if I may use the expression. But when you work hard, you must have a questioning mind. And that was what was taught to you. In fact, when I first joined the profession, on my first day, initially, my senior ignored my presence. Thereafter, he called me and he asked me, what were you doing? He used to regularly swim in the evening. When he came back after his swim, he said, what have you been doing? So I said, I've been reading this particular brief. This was a brief against the Commissioner of Sanchayita Investments. Then the next question he asked was, why is it in the original side of this court? So I thought I was very smart. So I told him, the address of the commissioner is Shashi Bhushan De Street. And Shashi Bhushan De Street is within the original side jurisdiction of the High Court. And that is why it's in the original side High Court. The next question was, there is no room for motherwit. There is no room for motherwit in the profession. And then he told me that Sanchayita Investments was carrying on business of money lending and taking deposits. There was a raid of Sanchayita Investments. A writ petition was filed. It went to the Supreme Court. The Supreme Court directed that a commissioner of Sanchayita Investments should be appointed, and that commissioner of and there would be a special bench constituted which would have original jurisdiction also to take up Sanchayita matters. And that is why these matters were being taken up in the original side. So my senior told me that when you get a brief, question everything that you see in the brief. And he jokingly said, you think of why the string is red in a brief and why the back sheet is blue. Of course, he smiled and said, even I can't give you the answer, but there must be a reason for it. And then I said, probably, so that you can identify one bundle of papers from another. Because the color strikes you, it attracts your attention. What is written there? What does FMAT mean? What does FAT mean? What does FA mean? Because on the first page, you'll find certain numbers. So FA would probably be first appeal. FMAT would be first miscellaneous appeal in tender. FMA would be first miscellaneous appeal. FAT would be first appeal in tender, which after being entertained would become first appeal simpliciter. Different high courts may have different rules with regard to the mode of numbering, the nomenclature that is used. So when you go to your senior's chamber, when you read a brief, you should question yourself about everything. why is this matter being filed in the High Court? How does the High Court derive jurisdiction? High Court's jurisdiction, first of all, it would have to have territorial jurisdiction. The matter we were discussing was a matter under Article 226 of the Constitution of India, which empowers the High Court to issue the writs of quo warranto, habeas corpus, mandamus, certiorari, and prohibition. What is a habeas corpus? Production of a person is production of the body of a person before the court. So this can also be a protection against illegal arrest, illegal detention. Quo warranto, asking a public authority under what authority he is holding a post. So where a person who is appointed to a post does not have the necessary qualification, a writ of quo warranto may issue. Mandamus, it's a command to an inferior authority either to do something or not to do something. And prohibition, it's a direction on a quasi-judicial authority not to further proceed in a matter. That's prohibition. And then, of course, certiorari, where you call for an illegal order and you can quash it. Under what circumstances would these writs lie? Technically, the power of the High Court is very wide. But the High Courts, the Supreme Court and the High Courts, the courts have evolved certain self-imposed restrictions on the power to entertain. Therefore, alternative remedy, as was being discussed during the Moot Court, is a ground for not entertaining. The existence of an alternative remedy is a ground for not entertaining a writ petition. Now, is the existence of an alternative remedy an absolute bar? No. And a writ petition may be entertained in spite of existence of an alternative remedy if the order impugned is in violation of the principles of natural justice. If the order impugned is without jurisdiction, where the order has been passed under some rule, some statute, which is ultra vires the Constitution of India. In today's Moot Court, some of you said that you were challenging the guidelines, the circular, apart from the fact that draft rules are usually, challenge to draft rules are not entertained because it has not taken force. But apart from that, on what ground can a statute be challenged? A statute can only be challenged when it violates a fundamental right or a constitutional right. When it is in excess of the legislative power conferred by the Constitution of India. You are aware that you have the first schedule, you have the second schedule, and the the first list, the second list, and the third list of the seventh schedule. The first list pertains to matters in respect of which the central government has the power to legislate. The second list contains the list of items in respect of which the state government has the state legislature, this parliament, the state legislature has the power to legislate. And the third list is the concurrent list, where both the state central legislature and the state legislature has the power to legislate. Under what circumstances can a state legislature, an act enacted by a state legislature, which may be somewhat inconsistent with a central legislature, and what circumstances can they prevail? So these are things you have to read, you have to understand. And as we told you time again, in this country, we have an adversarial system. And in the adversarial system, you have a judge, and you have the lawyers. You have the lawyers for the respective parties. A judge may be dealing with 50 cases in a day, or many more. It may not be possible for the judge to notice every point in your case. So you have to be fully prepared. You have to be thoroughly prepared to be able to assist the court. How do you do that? Have your questions and answers with a questioning mind. If the judge asks this question, this will be the answer. Question number 2, this will be the answer. Sometimes you may think that a judge is asking a question which is silly because you don't know why the judge is asking the question. You can't read the judge's mind. There may be something going on in the judge's mind which you may not have anticipated. But whatever be, whether the judge has a reason for asking the question, or let us assume the judge is asking a wrong question, the judge will ultimately pass the order. So you have to courteously, politely deal with the judge's question, answer the judge's question, and help the judge to decide in favor of your client. But just as you have a duty, all lawyers are officers of court. And as officers of court, they have a duty. They have a duty to be just and fair to the court. They have a duty to argue, but not to lie, not to mislead the court. So your ethics are very important. And you must remember one thing, that if you mislead the court once, that court will possibly never trust you again. But when you win the confidence of the court, then you will fare well for yourself. There are certain basic rules. Apart from hard work, you should learn to manage your time well. Don't just go on and on reading. Read intelligently with a questioning mind. Time management is extremely important. You should maintain punctuality. in court and for your chamber timings, remember one thing. You may be able to get away by giving wrong advice to one or two literate clients or some clients who do not know the law. But suppose you are appearing on behalf of the government and you had Mr. Goyal sitting there to instruct you. You gave one wrong advice, you would have been caught out straight there and then. Similarly, you have corporate representatives who know the law very well because they have also done their law. They have done company secretaryship, chartered accountancy, all of which require some learning of law. Many of them have qualifications as a chartered accountant and as a lawyer. So they are dealing with law all the time. So you have to be absolutely well prepared. The third thing is, listen before you answer. Because if you answer without listening, you will invariably give an answer which may be wrong. If you have not understood, it is better to ask. Just as you have a duty of courtesy to the court, you have no duty to be servile to the court. So if you feel that you are not being allowed to make your arguments, then very courteously but firmly you can put your case across, and that would not amount to contempt. We were having a smile amongst ourselves when the expression mischievous interpretation was used. And one of my brothers referred to Article 129 of the Constitution of India, because that pertains to contempt of the Supreme Court. So what constitutes contempt? Lowering the dignity or majesty of the court constitutes contempt, constitutes criminal contempt, when you lower the dignity or majesty. And when you do not carry out an order of court knowingly, then you commit civil contempt. I have taken up a lot of your time. This is a subject. Well, I was also elevated from the bar, and it is always said that the lawyers talk too much. So I was a lawyer, and for so many years, I hardly got the opportunity to talk. So now that I've been given the podium, I would perhaps go on and on till I was stopped. But to end, I once again congratulate all of you. I wish you well in life. This Moot court has also taught you one thing. Which side wins may depend on the strength of the case. So you may have argued very well, but your case may have been weaker. This also teaches you to be able to face defeat and victory alike when you appear in a court of law. So if you have not succeeded this time, don't be disappointed. You were very good. you will succeed the next time. Try and see what were the questions you could not answer. Go back and read the relevant provisions. I wish you all a very bright future in law. I assume that many of you will join the legal profession. After all, this is a professional course for lawyers. I hope and I appeal to some of you to join the judicial service, because you also need good judges. And whatever you do, wherever you are, please do something for the good of society. And remember, every law which you have today, we talk about economic justice. So, the topic today, it was related to economic justice. When you do something on the Protection of Women Against Domestic Violence Act, Scheduled Caste and Tribes Atrocities Act, it has got to do with social justice, political justice also. I refer to the 10th schedule and many other provisions of the Constitution of India. The Representation of People Act, the election petitions which are filed in court, and then of course even the civil law, tenants and law between tenants and landlords. If a landlord is evicting a tenant in violation of a statutory provision or in violation of a contractual provision, then there is a remedy under the specific Relief Act, and it is a question of shelter of the person. But then no person has a right to shelter if he is not entitled to that shelter. So, with that, I wish all of you a very bright future and I thank the authorities once again for giving me the opportunity to be here and to share my views with you. Thank you very much.
Thank you, ma'am, for your inspiring words. May I request everyone to kindly look at the screens to view the journey of Second National Moot Court Competition 2025. And now, the most awaited moment of the evening, the prize distribution ceremony. To announce the winner of the second National Moot Court Competition 2025-26, we invite on stage Ms. Jyotisikha Rajkashyap, convener of Moot Court Society, National Law University, Meghalaya.
We will first begin with the individual category of the awards. The first category of award is for the Best Speaker Female, and the winner is Harsha Shekhawat from TC 2515 Lloyd Law College. I kindly request Advocate Rohit Jain sir to kindly come forward and do the honors. Thank you, sir. Moving to the next award, the Best Speaker Male. And the winner is Rahul Bora from National Law University and Judicial Academy, Assam. I kindly request Advocate Pranay Agarwal sir to do the honors. Thank you, sir. The next category of award is for the Best Memorial from Appellant Side, and it goes to TC 2502, School of Law, Christ University. Next, we have the award for Best Memorial Respondent, and it goes to TC 2501, Symbiosis Law School, Pune. I kindly invite Advocate Abhishek Jain sir to kindly do the honors. Thank you, sir. Next, we have the award for the best researcher, which goes to Abhay Sharma from TC 2504, National Law University and Judicial Academy, Assam. May I kindly request Honorable Vice Chancellor, Professor Indrajit Dubey, sir, to kindly come forward and do the honors. Thank you, sir. And now comes the moment we have all been waiting for. I kindly request the team to kindly play the video revealing the winners of the competition. May I request Honorable Madam Justice Indira Banerjee ma'am and Professor Indrajit Dubey sir to do the honors. I kindly call upon stage the winning team, National Law University and Judicial Academy, Assam. Take the photo. I kindly Thank you. I kindly call upon stage the runners-up team of the competition, Assam University Silchar.
Thank you, sir. Thank you, ma'am. Many congratulations to all the winners. Your hard work and dedication truly paid off. Now, I would like to invite Dr. Ankita Chakrabarti, faculty co-convener of the Moot Society, whose tireless efforts have immensely contributed to the success of this event, to officially deliver the vote of thanks, expressing our gratitude to all those who made this event a huge success. Ma'am?
Good evening, distinguished guests, respected faculty members, students, and participants. As we draw the curtains on the second edition of the NLU Meg National Moot Court Competition, it is both an honor and privilege to deliver the vote of thanks on behalf of NLU Meghalaya. To begin, we extend our deepest gratitude to our Chancellor, Honorable Mr. Justice I.P. Mukherjee, Chief Justice of the High Court of Meghalaya, and our deepest gratitude goes to our chief guest, Honorable Madam Justice Indira Banerjee. We thank our Vice Chancellor, Professor Dr. Indrajit Dubey, whose academic vision and leadership have been central to the university's journey so far. Sir, under your guidance, in just 21 months, we have not only established ourselves but successfully hosted this flagship national level event for the second time. Our heartfelt appreciation also goes to our registrar, Srimati Karpa Nongbri, for her consistent administrative support and unwavering commitment to ensuring that everything ran smoothly behind the scenes. Ma'am, your efforts have made an invaluable difference to the success of this event. It was our utmost privilege to welcome and host the distinguished judges of final rounds, Justice Indra Banerjee, Justice Debangshu Basak, Mr. Anirban Ray, Mr. Rohit Jain, and Mr. Rishabh. We thank each one of you for taking the time to be with us, for lending your insights and experience, and for guiding our young mooters with such grace and clarity. Thank you. Our thanks also extend to the judges of the preliminary and quarter-final and semi-final rounds, whose contributions brought depth, fairness, and academic rigor to the competition. We also extend our sincere appreciation to all our sponsors and partners, without whom this event would not have taken the shape at this scale. We are especially grateful to Mahanta Sir, Advocate and former Advocate General of Meghalaya, Mr. Pranay Agarwal, Managing Partner at Agarwal et al., and our founding trustee of Tech Off for their generous support and encouragement. We would also like to thank SCC Online, our knowledge partner and media partner, for their continued collaboration, along with Times of India and our outreach collaborators, Law Bhumi and Just Corpus, who helped us carry our voice further and wider. Now, allow me to express my heartfelt gratitude to our faculty convener, Dr. Yogesh Mishra, and the faculty co-convener, Dr. Umeshwari Dakar. Their tireless efforts, vision, and unwavering dedication were the foundation of this event's success. To all our faculty members, thank you for believing in this initiative and supporting us throughout. Your presence and mentorship have meant a lot to our students and organizing team. To all the participating teams, thank you for your enthusiasm, preparation, and spirited engagement. Your presence has elevated this competition, and we hope this platform has been as enriching for all of you as it has been for us. Finally, we offer our warmest thanks to the many silent contributors, our admin staff, tech support team, drivers, gardeners, security personnel, and housekeeping staff. You are the backbone of this institution, the quiet force that ensures everything functions smoothly. This success belongs to you too. As we bring this event to a close, we do so with immense pride in what we have accomplished together and with excitement of what lies ahead. Thank you, one and all. Jai Hind.
Now, I'd like to call upon the student co-convener of the Moot Court Society at National Law University Meghalaya, Jyotishikha Raj Kashyap, to officially close the second National Moot Court competition at NLU Meghalaya.
I, Jyotishikha Raj Kashyap, convener Moot Court Society NLU Meghalaya, hereby declare that the second NLU Meghalaya National Moot Court Competition 2025-26 closed.
Before we conclude, we request all the dignitaries, participating teams, and volunteers to kindly assemble near the stage for a group photograph to capture this moment of celebration.
All the students and All the students and participants are requested to come ahead and stand near the chairs, please.
Thank you all once again for being a part of this wonderful journey. With that, we formally conclude the valedictory ceremony of the second National Moot Court Competition 2025-26 at Nlu Meghalaya. Have a wonderful evening.
And finally, I invite everyone to join us for the dinner. For students and participants, it's arranged near Julie Auntie's canteen, and for the dignitaries, it's in the conference room. Thank you so much. Jai Hind.